Mr. Calucci?
Well, I move that under Rule 13 I be permitted to cross-examine Mr. Vincent on a prior inconsistent statement. That statement being the statement of Mr. Howe, which Mr. Vincent has confirmed was his attorney at that press conference. Rule 16 permits a witness who testifies inconsistently on the stand to be cross-examined as to the prior inconsistent statement. It also permits extrinsic evidence of it, as long as the witness has an opportunity to explain it or deny it, and the opposing party has an opportunity to interrogate on it. All of that is just obviously place. He says he has an explanation. He's given it to us. The state is here to cross-examine him as it so chooses. So I think the requirements of 613 are certainly in place. The jury may decide to accept or reject his explanation. Under State versus Cianci, 430 Appendix 2nd, 756, 1981, such cross-examination is permissible. I know that during a break, the state was kind enough to provide us with another case, State v. Lerner, 308 Appendix 2nd, 324, 1973. That speaks about a statement of co-conspirator of knowledge should have been chargeable to the defendant, and it listed certain factors. I don't think it's applicable here, but I'm going to state the factors.
It's not applicable here. We're not reviewing under adopted admission. It's either whether it comes in under as a statement by a representative or an agent of the witness. I think that's the correct analysis. I'll hear from the state on that.
Okay.
But I want you to explain to me specifically what, I think I get it on the medical attention. So he basically said, he testified today that he was rendered attention by the defendant.
Yes.
And his attorney said something arguably to the contrary, correct?
Correct.
He claims that's not what he told him. He claims he told him afterwards that that was wrong. We have a combination of statements being given to an attorney who then is speaking on behalf. How is that attributable specifically to him?
Mr. Vincent?
Yes.
Because he's acknowledged it was his attorney, and as I think it's 801, statement by a representative is the person's statement. So he says, Mr. Howe is Mr. Vincent's legal representative, has the authority to speak for him, and what he says is binding upon him. So that's how it's attributable to Mr. Vincent. It's his representative, his legal representative. He speaks for him and did on that day.
But he just told us that that wasn't his statement.
But, well, that's the legal question for Your Honor. If it's made by his attorney, it's his statement. Now, he can explain it, as 613 says. And it's only for impeachment purposes. I mean, this is the rule. It's for impeachment purposes. Two different statements on two different occasions. My position is that statement by Mr. Howe, both of those statements about not hearing anything and the medical aid are attributable to Mr. Vincent.
Thank you.
Well,
Your Honor, it appears the court wishes to focus on 801 D2C, the statement by a person authorized by a party to make a statement concerning the subject. And Mr. Calucci has presented Mr.
Actually, I think it's the statement by the party's agent. They're arguably similar, but
That's fair enough, Judge. Fair enough, yes. Agent servant concerning a matter within the scope of one party's agency or employment. Mr. Calucci has offered Mr. Vincent, for purposes of the short hearing, to establish that relationship. And while there seems to be He's representing three people simultaneously, it would appear. He's receiving three different streams of information. And what concerns the state in this matter is the lineage of the statement that Mr. Colucci wants to confront Mr. Vincent with. How can we get at the heart of the core of what Dominic Vincent actually said when we have an attorney flanked by three clients, presumably who have been giving information to Mr. Howe with respect to the incident under question? That is the state's biggest problem. We can't attribute this directly to any of these statements directly to Dominic Vincent. If he wants to be confronted with a statement that he has made prior and that is inconsistent, that is fine. That is fair game under 613 and the rule in Queen Caroline's case. But that is not this situation at all. The lineages are not distinct enough for Mr. Colucci to say, you said this, didn't you, sir?
Do you agree that either or both of those statements, if attributed to Mr. Vincent, are inconsistent?
Not necessarily. Certainly, Mr. Vincent explained the incident about being able to hear what the defendant was saying and where he could hear him from. So those are not necessarily inconsistent. And with respect to the medical treatment question, well, what measure of first aid was applied? How did any one of the three explain the situation to Mr. Howe? Perhaps they saw, oh, a sweatshirt made into a tourniquet? That may not really be first aid, or the kind of first aid you would expect under the circumstances. It might be their shorthand way.
But that's an explanation.
It's an explanation, but of course we don't know the lineages of that information. And so how does Mr. Colucci attribute it directly and squarely to Dominic Vincent?
Okay. Thank you. So, starting off with the precursor to the analysis of the agencies, whether there's an inconsistent statement. If attributable to Mr. Vincent, the statements about whether Detective Dolan or Officer Dolan made any attempts to render aid are arguably inconsistent, so the court would find that they would be fair game on cross-examination if there's an agency relationship. In regards to the issue about the shouting, the court's not as persuaded for the following reasons. There are two clips. On the first one, on 6A, it appears that Mr. Howe is referring to what was being said in front of the car, which is consistent with what the defendant, what Mr. Vincent testified to. The 6B clip is a continuation of that. And Mr. Howe, if the court's recollection is correct, makes some reference to the fact that they can hear, we're still trying to determine that. It's an equivocal statement by an attorney who is either trying to gather information or make a determination, but the totality of those two statements, 6A and 6B, the court doesn't find are consistent, certainly not with this witness's testimony. We'll see what the other witness's testimony may be. In regard to the first one, which the court did find is inconsistent, the issues about aid, there's clearly an agency relationship. Mr. Howe is speaking on behalf of his clients. Mr. Vincent appears to have an explanation or response to that, which certainly can be teased out either during cross-examination or on rebuttal. So the court will allow the inquiry in regards to whatever clips those were. I don't remember, Mr. Colucci.
The exhibit number?
Yeah.
That was exhibit L2A and L2B.
And Mr. Colucci, just so we're clear, I expect that you will be inquiring the same way you did right now, which is to make reference to the statement as opposed to showing the video clips.
That's correct.
All right. Anything else at this time?